Good afternoon. Welcome to the House Criminal Justice Committee for February 23rd. Madam Clerk, please call the roll.
Representatives Beck, Campbell, Dixie, Doggett, Farmer, Griffey, Hardaway, Hawk, Howell, Halsey, Lamar, Lamberth, Moody, Russell, Sherrill, Vice Chairman Sexton, Chairman Curcio.
Here.
Mr. Chairman, you have a quorum.
Thank you, Madam Clerk. Members, any personal orders before we get started today? Seeing none, we will get right to it then. We have a calendar before us. I do have an announcement. Item number 2, House Bill 2657, which is actually being carried by me, will roll 1 week. So rolled 1 week. All right, that brings us back to item number 1, House Bill 2656 by Chairman Holsey. Chairman Holsey, you are recognized. You have a motion and a second properly before the committee, sir.
Thank you, Mr. Chairman, and thank you, committee. I do have an amendment here. I believe that we need to get on. It actually makes the bill.
Chairman Holsey, I want to make sure we have 2 that were filed. I think the one you want to move is coded 14059. Is that correct?
That is correct.
All right, we have a motion and a second on that amendment, and it looks like the amendment makes the bill.
It does.
So we'll go ahead and get that on the bill, and then we'll have you explain your bill. All those in favor of attaching amendment coded 014059 to House Bill 2656, please signify by saying aye. Aye. Those opposed, you adopt. Chairman Holsey, you're recognized.
Thank you, and thank you, committee, for your time and your indulgence. And I'm here to present House Bill 2656 on behalf of Speaker Sexton. It's also known as Truth in Sentencing. This legislation is vital for holding violent offenders accountable for their actions while also protecting victims in the public. But it does something else. It accomplishes what I've dealt with for years in the police department before I retired, and what victims' families have dealt with for years and years and years. And that's when a judge gives a sentence or a jury gives a sentence, and the family who's left behind to pick up the debris asks, when is this guy going to get out of prison? Nobody can give them an answer. The district attorney cannot answer, the judge cannot answer, the Department of Corrections cannot answer, because nobody has a formula on how to figure out sentencing credits and how long and how much. And so they're very surprised sometimes if they've sat in jail for a year and a half pretrial and they gain day for day, sometimes 2 for 1, and 6 months after the sentence, they come up for a first parole hearing. So this bill fixes that with the violent types of crimes. And this bill says that whatever a judge or a jury gives and sentences, that's exactly how much time will be served. Doesn't do away with sentencing credits. You can use them for other things, for benefits inside the penitentiary, but you can also use them because most of the time these crimes do not stand alone. They'll have 2 or 3 other crimes that go with them. When the mandatory 100% of the first crime is filled, then sentence credits can be used on what's left. And these crimes there's 23 of them. Aggravated assault, if the offense used a deadly weapon. Aggravated assault, if the offense used strangulation. Aggravated assault against a first responder or nurse, if the offense involved the use of a deadly weapon. Aggravated assault against the first responder or nurse, if the offense involved strangulation. Second-degree murder, voluntary manslaughter, criminally negligent homicide, vehicular homicide, reckless homicide, aggravated vehicular homicide, involuntary labor servitude, trafficking persons for forced labor or services, possessing a firearm or antique firearm during the commission or attempt to commit a dangerous felony, attempted first-degree murder where the victim suffers serious bodily injury, aggravated kidnapping, especially aggravated kidnapping, aggravated robbery, especially aggravated robbery, carjacking, aggravated burglary, especially aggravated burglary, aggravated arson, and the manufacture and delivery or sale of a controlled substance where the person has 2 or more prior convictions of the same offense. Again, they cannot be reduced by sentencing credits. Whatever a judge gives, whatever a jury gives, is exactly the amount of time to be served. And that is the essence of the bill.
Thank you, Chairman Holsey. Appreciate your work. I appreciate your work on this. I have a similar bill, not to go off topic here, that'll be coming through committee that deals just specifically with the burglary piece of this. So I know you've worked hard on this. I appreciate your efforts. Members, we do have some folks on the list to testify, but before we do that, does anybody have any questions for Chairman Halsey? Okay. Representative Dixie, we have adopted the amendment, so we're on the bill as amended. Okay, all right, we're good. Okay, without objection, then we are going to go out of order to hear from some witness testimony. So,
Thank you.
out of session. First on our list, we have Mr. Matthew Charles from FAM. And Mr. Charles, I know you've been to this committee several times. If you want to stand or sit, either way, whichever way you're more comfortable, if you could please just introduce yourself for the record and then share with this committee whatever you'd like. You'll have 3 minutes, and then there's unlimited time for questions.
All right. My name is Matthew Charles. I'm a resident of Nashville, Tennessee, and a policy associate for FAM.org. FAM opposes House Bill 2656, which will require prisoners to serve 100% of their sentence. We believe this bill will change dramatically how the Department of Corrections correct, swell jail and prison populations, lead to the need to build more prisons simply because prisoners are being required to stay longer than necessary for non-rehabilitative purposes, increase prison rule violations, cause less people to participate in necessary rehabilitative programs so that instead of them coming out changed, better, and employable, they will be returning the same or worse and more likely to reoffend, increasing the rate of recidivism. Thank you, Chairman Kersey, on the committee members.
Thank you, Mr. Charles. Any questions for our witness while he's here? Representative Lamar, you're recognized.
You mentioned that it will increase prison populations and costs. Am I correct?
That is correct.
Can you explain why you believe that in more detail?
Okay. Chairman Kersey.
Mr. Charles, you're recognized.
Due to the fact that the United States prison population was well over 2.2 million for a reason. The reason that it was overpopulated was the fact that people had longer sentences. And we know that those people that have longer sentences, because 9 million people are released from prisons. 9 million people are released from jails per year. 600,000 are released. Let me get this fact straight. Okay, 600,000 people are released from jail each year. 9 million people are released from prisons, or vice versa, since it's not coming through. But because of this, you have people continually coming in prison. So long as people are continually coming in the front door, and those people that have the sentences that are longer are still there, then it will increase prison populations. We believe that it will affect state and local jails, state prisons and local jails. We also believe that it would take the state of Tennessee to construct more prisons to hold those prisoners that they are keeping longer.
Representative Lamar.
Thank you. That's all the questions I have for now. Thank you, Mr. Chairman.
Next up, I have Chairman Hawk. You're recognized.
Thank you, Mr. Chairman, and thank you for being here. I think I've heard you speak a time or two, seen you on the news a time or two as well, so thank you for your advocacy. Give me a little bit of idea of what programs you're operating in prisons right now.
Okay. Mr. Charles.
Well, I work for an organization called FAM. FAM has been around since 1991. That organization is actually based in Washington, D.C. When Julie Stewart, the founding member of FAM, created that organization, it was because her brother had received a mandatory minimum sentence of 5 years. He was a first-time offender, and he was given 5 years. So in other words, it was looping him in with the sentence that someone who had a more heinous crime received the same time for. And since then, FAM has been working on state issues, federal levels. They have helped change laws, policies in many states just based on sentencing and prison conditions. But as far as any programs that we specifically have ourselves, FAM doesn't do that.
Thank you.
Chairman Hawk.
And thank you, Chairman Kersey. Forgive me, I misunderstood. I've talked to so many people about work within prisons and trying to work with individuals to get them ready for the workforce. Okay, thank you so much. Thank you.
Thank you. Next on my list, I have Representative Hardaway. You recognized.
Thank you, Chairman. And Good afternoon to you, sir. I also have heard you before. I appreciate your work. When you're looking at other states, can you extrapolate information from those states that have followed this path and tell us whether they're satisfied with their rate of success?
Mr. Charles.
Thank you, Chairman Curcio. We looked at two states, the state of Georgia and the state of Arizona, that both went this direction. And it was found that it did increase rule violation on the prison. It did cause those people to participate less in rehabilitative programs that would have prepared them for release, and it didn't deter crime. We understand that the data suggests that longer sentences don't deter crime or increase public safety, sir.
Representative Hardaway.
Mr. Chairman, that kind of summed it up for me. Thank you, sir.
Thank you, sir. Next on my list, I have Leader Lamberth. You recognize?
Mr. Charles, good to see you again, and always a pleasure, and appreciate your testimony. I know we discuss these issues many times. We're both very passionate about these issues. I know that some of the information gets out there pretty late sometimes on amendment and fiscal notes and everything else. We spend about $1.1 billion on prisons in Tennessee, and I know you've looked at those numbers. The specific fiscal note on this bill is only about $27 million additional dollars, so a scintilla of a percentage of the overall budget. Were you aware of the fiscal note on this particular bill? I know you said earlier that, this bill might cause us to build more prisons, and I would humbly say I don't think this particular bill would, but what do you think?
Okay, I think when I was, sorry.
You recognize, sir.
I think when I was speaking as to Representative Lamar's comment, she was saying, would this, as far as exceeding or giving longer sentences, cause more sentences to be built? So it was an answer to that. The fact that you're keeping people longer automatically, logically, says that you will have to build more prisons to store those people, since the front door of people are still, open for them coming in.
Leader Lamberth.
And I just want to highlight that in this particular bill, and I hoped that was more of just kind of a larger, kind of amorphous comment on additional prison population, but this particular one deals with some very targeted and violent crimes. Wanted to also just kind of make a point and get your thoughts on this. You continue to say that the recidivism rate is not changed by longer incarceration times. It's fair to say that while someone is incarcerated, the recidivism rate for that particular individual is 0%. Is that fair enough?
Mr. Charles.
I don't recall stating that I said that the recidivism rate didn't change if they do longer sentences. I said that it would raise. In other words, a person has to do more time. The data shows that because they serving longer on their sentences, they're more quickly to recidivate. That's what I had stated initially.
Leader Lamberth.
Yes, sir. Mr. Charles, what I'm trying to get at is that there are some individuals who fall within within violent crimes, and you're familiar with some of the crimes I'm talking about and familiar with the crimes in this bill, that if those folks are incarcerated, I mean, would you concede that during the time that they're incarcerated, they're not hurting anybody else? I mean, the recidivism rate on those folks is 0%.
Mr. Charles.
Okay. I would agree with you on that point due to the fact that that is a form of incapacitation. As long as that person is taken away from the street and put into prison, then as long as he's held in prison, the only offense that he can commit is those offenses in prison. But once he's released, he may come out the same way or worse and reoffend, and therefore you have a new crime victim.
Leader Lamberth.
And that, Mr. Charles, is where you and I have always agreed that, I mean, what we do with folks and what services we provide to folks while they're incarcerated is critical, that those be very high quality services and that they be available to everyone, and then how we transition them back in. And that, you and I definitely share a zeal to get that part of it right. I think we're just talking about sentence length in this one. So thank you for your testimony, and always thank you for the gentlemanly way about that you describe issues that are very passionate. I think it's rare that I've seen you without a smile on your face, and we deal with very serious issues, but you're a gentleman, sir, and a scholar, and I deeply appreciate your testimony. Even when I disagree with it sometimes, I still deeply appreciate it. Thank you.
Next on my list, I have Vice Chairman Sexton. You recognized.
Thank you, Mr. Chairman. Are you associated with Men of Valor?
Mr. Charles.
No, I'm not associated with Men of Valor. Some of my friends are actually Raul Lopez, and he invited me to speak at their event yesterday. So I'm not as far as personally associated with them, but I'm aware of them, and I like the work that they do.
So I'm not dreaming then. I did hear you speak yesterday at the Men of Valor.
Mr. Charles.
Yes, I did.
Okay, well, let me just say this about that. I appreciated your testimony, sharing your life, your history, and I appreciate the work that you're doing now. I believe in truth of sentencing, but I believe we've also got a problem, and we need reform. I think that there are some low-level crimes that people are spending way too much time in prison. And I'd like to see the work of Men of Valor and other organizations that help acclimate these prisoners back into society, helping them get a job, helping them get a driver's license, finding them an apartment, working with their families, getting their families back together. So thank you for the work that you do. I believe that we owe it to the families of victims that they know what time is going to be spent in prison for some of their loved ones that has been wronged through murders or whatever that it might be. But again, I believe we do need reform. I believe that there are some things that needs to change. But thank you for what you do. I believe in truth and sentence. I will be voting for this bill. But maybe we could get some get some different sentencings that's more fair to people, because I think there is a problem. And thank you. Thank you, Chair.
I'm able to respond.
Okay, I have no one else on my list for our witness, so thank you, Mr. Charles, for being here. We appreciate you today.
Was able to respond to?
Oh, sure, certainly. If you,
Okay, thank you, Spicer. Okay, sir, I agree. I believe that when a sentence is imposed, that the victim, as well as the person serving the sentence, should know how long that person is. My thing is that a person that has to serve 100% of that sentence means it closes the door for them to have any incentive toward rehabilitating themselves, unless they just are personally motivated to do so. And I believe that whenever you take those incentives away from some of the people, especially since we're talking about violent crimes, we're talking about taking that away from the hard cases. Those people that we need to provoke or try to invest in and do whatever is possible to make sure that they come out different than they went in. Because over 95% of people that are incarcerated are going to return to their societies. So we just want to make sure that those people that are returning to their societies, that are going to be our neighbors, are coming out a different person. I'm not saying how much time they should actually serve, but I'm just saying that 100% of that forecloses the ears and hearts of some of those that never had their ears and hearts open from the start.
And I believe that that is a valid point. I think that's a valid point when you're talking about taking the carrot away. However, knowing the amount of time that you're going to spend, not living on that roller coaster, maybe I'll get out, maybe I won't. They know the amount of time that they're going to spend. They can spend that time studying or learning a craft. There's many things that they could spend that time doing. I believe it should be reduced in many cases, but it is a valid point that you're making. And if you don't mind, you shared yesterday that you spent many years in prison. Is that correct?
Mr. Charles.
Yes, sir. I was given a 35-year for a nonviolent drug offense. That's not to say that I wasn't a violent offender in the past. I did 22 years on that offense. The First Step Act passed, signed into law by President Donald Trump. I ended up being the first recipient of that and invited to attend the State of the Union as his guest. And since then, I've been able to go around the country speaking with legislators and governors about the need for criminal justice reform, sir.
And how many of those, how many people were pardoned by President Trump under that out of the United States? Do you remember?
Well, I don't know how many people that, oh, I'm sorry.
You're recognized.
Okay. I don't know how many people that the president actually did pardon.
On this program,
but
just
I know-
this program.
But I know that under the First Step Act, anywhere from 7,000 to 10,000, with the possibility, since compassionate release was grouped into that, close to 20,000.
Representative Sexton.
And I'm through, Chairman. Thank you for indulging this time. I just hope everyone heard your testimony. I think it is a powerful testimony. You were let out after 22 years. because of President Trump and you have made a difference in a lot of people's lives. And I just want to say thank you for that. And like I said, I hope if you didn't hear his testimony, maybe you could go back and look at this video because it's a powerful testimony. Thank you, sir.
Thank you. Next on my list, I have Representative Griffey. You recognize?
Thank you, Mr. Chairman, and thank you, Mr. Charles, for being here. Appreciate it, and everyone, I think, is appreciated and heartfelt that your personal story in turning your life around. I do want to point out, though, and ask you if you agree or disagree. I think the statistics do demonstrate that the United States saw its greatest decline in violent crime at around the same time that we imposed the mandatory minimums for 18 U.S.C. 924C using a gun in furtherance of a drug trafficking crime or a crime of violence. I mean, those two acts. Is that really a disputed fact in your mind?
You're talking about on the federal level? Because that's
Probably the federal level. Let's leave it federal level for purposes of discussion.
I can
Mr. Charles, absolutely.
Yes, I would agree. That and 851 enhancement, sir.
Thank you. That's all I have.
Okay. I see no further questions for our witness, so thank you very much, Mr. Charles, for sharing that today, and appreciate you being here.
All right, thank you for having me,
sir.
sir.
Chairman Halsey, we have next on our list, and I'll let you introduce our next witness.
Thank you, Mr. Chairman. The committee, I want you to meet Mr. Andy Rayner and his wife, Keith, and his sister-in-law, Missy. And I want you to hear what they have to say about their son, Drew.
Mr. Rayner, thank you for being here today. I know Chairman Halsey just introduced you, but if you would please just state your name for the record, and then please share with this committee whatever you'd like.
Yes, sir. Good afternoon. My name is Andy Rayner. I am from Memphis, here today with my wife, Keith, and my sister-in-law, Missy. Thank you for Mr. Chairman and members of the committee for allowing me to speak in support of this legislation. My son, Drew, that's his picture, was shot and killed at around 5:30 on the morning of Sunday, October 3rd, 2021, in the house he shared with 3 roommates near Rhodes College in Memphis. Drew was 22 years old, and he was a senior at Rhodes. He was the oldest of our 4 children, and he accomplished a great deal in his short life. He was awarded the Clarence Day Scholarship at Rhodes, and he was a leader on that campus and in his fraternity. He was majoring in English with a minor in music. Drew was an accomplished musician and a singer and played in bands at Rhodes and Christian Brothers High School. While at CBHS, he was an award-winning honor student and a varsity wrestling letterman. At church, he was an altar server. He sang with the choir and was very active in the youth group. Drew was an Eagle Scout. Most of all, Drew was a kind, gentle, and caring person who was loved by his family and friends. On the morning of October 3rd, Drew and his girlfriend were asleep when 3 or 4 people kicked in the front door of the house and robbed Drew's roommates of their wallets, phones, and video games and laptops. They then held Drew and his girlfriend at gunpoint. They threatened to rape and kill her in front of him, and then to kill him. Drew, at some point, tried to disarm the gunman, and during the struggle, he was shot in the chest, and his girlfriend was shot in the hand. While chasing his killers out of the house, Drew collapsed and died of his injuries in front of his friends. He'd caused the gun to jam, and the investigating officer told them that Drew's heroic actions most likely saved their lives. So my son died defending the people he loved. So far, 1 person has been charged in Drew's death. At the time of the murder, this person was on probation for aggravated burglary and other crimes. He was convicted in 2018 and sentenced to 6 years, but was released in 2020. That was his 3rd conviction for aggravated burglary, having served a few months for the 2 previous convictions. He has an extensive record of other crimes. This person chose not to take advantage of the many opportunities given to him to reform his life, and in my opinion, he should have been in prison. If this law had been in effect, I would not be here today. Drew would be preparing to graduate from college and enter the next phase of his very promising future, having fun with his friends and celebrating with our family. There were 30 homicides in Memphis in the month Drew was killed, and 340 in the year 2021. And I hope I speak on behalf of many of those families who have been affected as we have. The Shelby County District Attorney supports this legislation and tells me that all of the district attorneys in Tennessee do as well, as does Chief Davis of the Memphis Police Department. I respectfully ask this committee to help protect the people of Tennessee from violent criminals by approving this legislation. And thank you all for allowing us to be here and share Drew's story today.
Mr. Rayner, thank you so much for being here, and I know I speak for the rest of the committee when I say so sorry for your loss, and thank you for standing up there and sharing that with us today.
Thank you.
And members, if anyone has any questions for our witness, be happy to call on you. Okay. Representative Hardaway, you're recognized.
Thank you, Chairman, and thank you, sir, for being here. Thank you to the other family members. I remember the case well. As you know, I'm a state rep out of Memphis, and it takes something special for you to have the courage, in spite of your grief, to appear before the committee to try to make something positive out of such a tragic situation. So I thank you for coming. I thank you for your testimony.
Thank you. We hope we can help.
Thank you very much for being here, sir.
Thank you.
Members, we will go back into session. We're back in session, and Chairman Halsey, we're back on your bill as amended. I do have Representative Dixie on the list when we're back on the bill. So, Representative Dixie, you're recognized.
All right. Thank you. Thank you, Mr. Chairman. I got a couple questions. First, they're not in law enforcement. What does aggravate, when you put aggravated in front of something like aggravated robbery or especially aggravated, what does that mean?
Chairman Halsey.
Usually aggravated is if you have a weapon, especially aggravated is if you use it.
Okay.
Chairman Dixie.
So I guess my question is, I'm looking at this list, and most of them are, I guess, what you would consider violent crimes. But when I look at the one about the manufacture, delivery, or sale of controlled substance, and you have 2 or more prior convictions, what was the reasoning behind adding that?
Chairman Halsey.
I think that it is a repetitive crime because in order to fit into this category, you have to have been convicted of the same offense 2 prior times. And it has to be a Class A or B or C felony, which means that if you're charged with the manufacture or sale of drugs, that's a whole lot of drugs to get you to a Class B felony. If it was marijuana, it's 300 pounds. So it's the repetitive nature of it. And most of the time in my career, folks I dealt with in that category, moving that kind of issue and that kind of lifestyle were lawless across the board and were repetitive.
Chairman Dixie.
Well, in my day-to-day business, what I do normally, I had a young lady. She had an issue with alcohol. And she went to this store that she goes to, every corner store. Everybody knows her, knew she was. And she was drunk the day she came in. And the one day she came in and she didn't have any money, and she threw like a bottle of pills on the counter. It was like, here, take these pills. And she went and grabbed a beer and walked out. So instead of getting charged with shoplifting or whatever it was, she was charged with sale of a controlled substance. And there was a mandatory minimum sentence that she had to serve from that. And instead of her being able to get the help, I was able to help her to get into the Lord Elam mental health and controlled substance facility at Meharry. And she was able to clean herself up. But it didn't matter if she cleaned herself up or not, because she had to face this mandatory minimum of 3 years. And she was not a drug dealer. She just had an alcohol problem that needed to be tended to. And I guess that's why it kind of gives me a little reservation about this. I understand some of the other the other ones, anything that says especially or aggravated in front of it. And some of these are very violent crimes, but that particular one gives me a little concern when we add that in there.
Chairman Halsey.
Thank you. In the bill, it says, as defined in 3917-417, where the instant offense is classified as a Class A, B, or C felony. Again, in her condition, it would not be anywhere close to these. These are big felonies for moving a lot of drugs, and it's repetitive. You've had to had 2 convictions that serious prior to this.
Chairman Dixie.
Thank you for your explanation. I appreciate it.
Next on my list, I have Leader Lamberth. You recognize?
Thank you, Mr. Chairman. And I'm Sayer sitting next to the speaker, but I appreciate the speaker and the presenter of the bill bringing this piece of legislation. I think everybody on this committee knows how I feel about truth in sentencing. But Mr. Rayner, thank you for your testimony. I met with you earlier just before the committee, and I told you that your words would matter to us, and it does. And I can't imagine how hard this has been when in 2018 you know that this person that has now been charged with the death of your son got a 6-year sentence and should have been behind prison walls instead of out killing your baby boy. It matters what you say to us. It matters the laws that we pass. And it all doesn't sit on a spreadsheet or come out of a task force or a think tank somewhere. Sometimes it can be folks like this just stepping up saying, hey guys, these are real lives. If you're on the fence on this bill, please listen to the words that these folks have said and vote for it, because it matters what we put on the books down here. There's always going to be outliers out there of folks that need help that we can help. There are lots of ways to do that. But the man that killed their baby boy got a 6-year sentence and should have been behind bars. This bill does that. That's all I got to say, Mr. Chairman.
Thank you, Leader. Next on my list, I have Chairman Howell. You recognized?
Thank you, Mr. Chairman. And I, too, want to echo the leader's comments. I appreciate the speaker and you, Chairman Halsey, for bringing this bill. I was just sitting here reflecting on some cases in my own home district, tragic situations not unlike what you've brought here today. And I was thinking, I believe in redemption because I've been redeemed. I believe in mercy, but I believe it has to be tempered with justice. And I've observed that the discussion that we've had around several bills having to do with sentencing reform always focus on the perpetrator, the person who is in prison or the person who committed the crime. We're concerned about them, but there's virtually no discussion about justice for the victims. And I was just sitting here thinking and looking at this beautiful couple that's here and testified before us. Their son was killed. I know what it feels like to lose a son. Not like you did, but I know what it feels like. And I can empathize with you. But I want to tell you that when these criminals are sentenced, the families also receive a life sentence of pain and sorrow, regret, and of memories that never go away. So I'm glad to support your bill. Thank you for bringing it.
Thank you, Chairman. Next on my list, I have Representative Griffey. You recognized?
Thank you, Mr. Chairman. I just wanted to say I think the number one function of government is to protect the community and protect the innocents. And I think it's undisputed that we saw the largest reduction in violent crimes in America when we had mandatory minimum penalties for individuals committing violent crimes or drug crimes with firearms. They got mandatory minimum sentences, primarily in the federal system, when you serve 85% of your sentence, regardless, no parole in the federal system. This bill is a major step in that direction. I applaud that. I thought I'd already signed on to it. If I haven't, I do intend to sign on to it. Sure, there may be some concerns. We've got 0.5 grams of meth is a B felony. That's not a very large amount, and we've got major meth problems. That's something to look at for a different day. If we don't do this, we are failing in our mission to protect the innocent folks in our community. So thank you very much for the Rayner family for being here and sharing that your sorrow with us. Thank you.
Thank you, sir. Next on my list, I have Representative Hardaway. You recognized?
Thank you, Chairman. And I don't know, the sponsor may or may not know this. Is there a figure, a number for the rate of recidivism for the federal corrections institutions?
Chairman Halsey.
I'm sorry, I do not know. I know they have mandatory sentences, but I don't know what the recidivism rate is. I'm sorry.
Okay, and thank you for that.
Next on my list, I have Representative Dixie again.
Quick question. I meant to ask this earlier. Is this bill retroactive, or does it start on July 1 of 2022, 23?
Chairman Halsey.
It is not retroactive. It's from this point forward if it passes. Yeah.
Next on my list, I have Representative Lamar.
Thank you. How much does this increase the state budget by?
Chairman Halsey.
The fiscal note says $40,693,000.
So we
Representative
already
Lamar.
Or do I have the one? I might have the wrong fiscal note. $27 million. My bad.
$27 million. And our corrections budget is already over $1 billion.
It is.
Is corrections the department that costs the most money here?
Chairman Halsey.
Nick, you're talking about overall budget for the state? No, education is the number one.
Number one.
Yeah.
And corrections, is corrections number two?
I believe it's 2.
Representative Lamar.
No, it's not 2.
You recognize.
Is my go?
What's 2? Okay.
Chairman Hawk, you recognized.
Thank you for clarification. And so folks on the budget committee may realize education and healthcare are 1 and 2. You've got transportation, you've got other safety departments, and the $1.2 billion in corrections, although it is a substantial amount of the $52 billion budget we're looking at, it's top 10, it's not top 2. So thank you.
Thank you. Representative Lamar, we're back on you for questions for Chairman Hawk.
Thank you so much. And thank you, Chairman Hawk, for the clarification. Top 10. Additional $27 million to incarcerate more people. While I think these are some of the most egregious crimes, and I don't take those lightly. I am concerned about, on my heart, the fact that we're steady increasing prison populations and the prison cost. And we could reallocate that same from my understanding, they can serve this amount of time anyway. But we can take so much more of that money and invest in preventative measures so no one even has to get here in the first place. And I'm not a no, but I'm definitely not a yes. I just have a lot of heartburn about the fact that we are further increasing this prison population, and there are so many different other ways and avenues we can take to prevent violent crime. And so I'm just wanting to put that out there, what my sentiments are, as someone who, y'all know I've been trying to work hard for the last couple of weeks on gun violence issues. It's a big issue. It's a problem. But I don't know if this is all the way to attack that. So I just want to say this. I got heartburn about that. I'm not a no, but I'm not a yes. But I do have concerns, and I'm sitting over here having a conversation with God about it right now.
Thank you.
Thank you. Finally on my list, I have Speaker Sexton. Speaker Sexton, you're recognized.
Thank you, Mr. Chairman. So you mentioned that 2018, but that individual's criminal history dated back to 2008. And so this was a 14-year process in the judicial system of someone continually being slapped on the wrist for 14 years. Up to the end point today. They were charged with aggravated burglary 3 separate times. And people want to say it's a nonviolent crime because they just happened to be home. Well, the 4th time, somebody was home. So the question is, what's a life worth? What's the value on a life, on a criminal justice system that only gives somebody less than 18 months for 14 years of criminal history. Some of that was nonviolent. We get it. We understand it. But not all of it. And as we sit here and we talk about increasing prison populations and what the cost is, what's the cost on society to allow that to continue to build up over all the years? And there's legislation coming through for recovery courts for people who have mental health issues, people who are drug addicted, people to try to get them the help they deserve and need and maybe not go to prison. That's just as valuable. Having things in prison, like the gentleman spoke about, programs to help people to reassimilate back into society, those things are needed. But you also have to say, not everybody deserves to get out of jail because they got good time for credit. Why couldn't you offer them the same services to get the benefits of TV and other things in jail that they have the comforts of? They don't have to just get the good credit to get out early. But there should be a standard where certain types of crime, violent crime, horrific crimes, horrendous crimes, where you tell the victim's family, if they commit this against you, they do every single day. And then when they get out, we'll have the programs to help them, potentially, and have the things ready for them. But almost always, an individual doesn't start out committing a violent crime. Sometimes there's crimes of passion that start off that way. But if you look, Chairman Halsey sitting there who's in law enforcement, I guarantee you it starts off as petty theft and it builds up. And it goes and it goes and it goes. And they've had ample opportunity to turn their lives around. And they just didn't want to. And so as a state, do we sit here and say, you know what, we want people to be rehabilitated. We want to help you get over your addictions or your mental health issues. But if you create or you commit certain crimes, aggravated, especially aggravated, second-degree murder, why are we sitting here dishonoring the memories of those victims and their families by letting someone who committed aggravated burglary get out at an estimated at 1.5 years in our state? They get out in 1.5 years on average. And so as we sit here and debate this isn't about not having compassion. This is about having compassion for the victims, for the families, but also having compassion for the person who committed the crime. Sometimes the best deterrent is a Swiss stick to make sure that they don't want to commit it. They still have to be charged. They still have to be convicted. It's not a guarantee. But if we watch what's going around the country, a lawless society where everybody gets out and serves very little time, what's the means of the consequence? What do they believe that they can do? They don't have any respect for laws, any respect for law enforcement, any respect for anyone's life, respect for anyone's things. So I think when you look at violent, and in this is trafficking of humans. Think about that. We won't even talk about what they get charged and what they serve for trafficking humans in our state if they get caught. So when you look at this is just truly about violent criminals, a certain level of criminals that should serve every single day. That's compassion for the victims and their families. Thank you, Mr. Chairman.
Thank you, Mr. Speaker. Members, I have no one else on the list, so without objection, we're ready to vote. All those in favor of sending House Bill 2656 as amended to Finance, please signify by saying aye. Aye. Those opposed? Sir, your bill passes. You head to Finance.
Thank you, sir.
Thank you. If you wish to be recorded with a no, please let the clerk know. Members, that brings us to item number 3, HR 129, which is by me, so I will pass the gavel down to our Vice Chairman.
Thank you, Mr. Chairman, and we do have a motion.
Thank you, Mr. Chairman and committee. Members, House Resolution 129 simply amends the changes, ratifies the changes to the Tennessee Rules of Criminal Procedure. Thank you.
We have a question on the bill. No objections. We're voting on House Bill 0129. All in favor say aye.
Aye.
Opposers, no. It moves on to calendar.
Thank you, Mr. Chairman. Thank you, committee. Members, that takes us to item number 4, House Bill 2269 by Vice Chairman Ogles. Vice Chairman Ogles, you're recognized. Sir, you have a motion and a second.
Thank you, Chairman, members of the committee. This piece of legislation changes right now in the state of Tennessee. I'm sorry, I got caught up with that. If you're convicted of first-degree murder, under current law, a person convicted of first-degree murder for the killing of another person in preparation or attempted preparation of rape, rape of a child, or aggravated rape of a child must be sentenced to death, life imprisonment without parole, or imprisonment for life. This piece of legislation takes the lesser of those charges, imprisonment for life, off the sentencing. So you would be, much in the story of Drew earlier, you would be sentenced to death or life imprisonment without parole because he threatened to rape that woman and killed that young man during that offense. So with that, I'll take any questions.
Members, you've heard the explanation. Any questions? Any objection to the question? Seeing none, Chairman Dixie, you're recognized.
I think I was reading when you said that. You said it's going to take out which part of it? I know you said death or life imprisonment. It was one thing that I missed.
Vice Chairman Ogles.
Thank you, Chairman. It would take out the lesser of the 3 sentences, which is imprisonment for life. So the person would be sentenced to either death or life in prison without the possibility of parole.
Chairman Dixie.
Okay, I got it.
Okay, no further discussion. Question's been called. All those in favor of sending House Bill 2269 to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman, members of the committee.
That brings us to item number 5, House Bill 1907 by Chairman Kiesling. Chairman Kiesling, you're recognized. You have a motion and a second.
How's that? Oh, now. Thank you, Mr. Chairman.
Yes, sir, you're recognized.
As you may recall, members, from our subcommittee meeting last week, the Governor Lee's first year in office, we unanimously passed the elimination of the state expungement fee. We felt then, as we feel now, that by removing any financial barriers, that we can help first-time offenders get their life back on track. This bill would eliminate the $100 application fee for a diversionary program for first-time offenders. Now, please note, diversion is exclusively for individuals with no prior convictions. Now, I can get into there's a couple of different types of diversions. I can get into that, Mr. Chairman. I can also get into just who qualifies, but I think the simplicity of this is pretty much been mentioned, and with that, I'll entertain any questions regarding this.
Members, you've heard the explanation. Any discussion? Leader Lamberth, you're recognized.
Thank you, Mr. Chairman. Mr. Chairman, good to see you again today. Obviously support the bill, be voting for it. I was going to file an amendment on this bill. Due to the holiday, I don't believe I got it in on time, and so I'll be withdrawing that amendment and handling that through a budget amendment later on, hoping to get 4 additional expungement positions for the TBI. They really need it, whether this bill were to pass or not. I mean, they're understaffed and underfunded right now at the TBI. And again, I'll reiterate with this committee, I was invited over to tour their facility, specifically the expungement division, and I would encourage every member of this committee to do so. They are wonderful people that work all day long just on expungements, and so really neat to see the ins and outs of how that works. But I'll be doing that in a budget amendment, so I just wanted to announce that publicly that withdrawing any amendment of that nature. Thank you.
Thank you.
Leader.
Okay, any objection to the question? Seeing none, all those in favor of sending House Bill 1907 to Finance, please signify by saying aye. Aye. Those opposed? Sir, you head to Finance.
Thank you, Mr. Chairman and members.
Yes, sir, thank you. That brings us to item number 6, House Bill 1691 by Representative Campbell. Representative Campbell, you're recognized. You have a motion and a second.
Thank you, Mr. Chairman and members. This bill came to me from our state's Attorney General here in Tennessee. Recently, 2 United States Supreme Court actions have indicated that the court frowns upon the idea of excluding a spiritual advisor from an execution chamber. And in one of those cases, the U.S. Supreme Court actually explained that spiritual advisors cannot be excluded because the Religious Land Use and Institutionalized Persons Act provides expansive protection for prisoners' religious liberty. In Tennessee state law, for a spiritual advisor to attend an execution, that person must be a priest or minister of the gospel. This changes that language, replacing it with a member of the clergy. Thank you.
Members, you've heard the explanation. Any discussion? Seeing none, any objection to the question? Seeing none, all those in favor of sending House Bill 1691 to Calendar and Rules, please signify by saying aye. Aye. Those opposed? Sir, you head to Calendar and Rules.
Thank you.
Thank you. That brings us to item number 7, House Bill 1922 by Representative Hicks. Sir, you have a motion and a second. I see an amendment coded 13839. Do you wish to move forward with that amendment?
Yes, thank you, Mr. Chairman.
All right, we have a motion on the amendment and a second. The amendment makes the bill, so we'll go ahead and get that on. All those in favor of attaching House Bill 138, all those in favor of attaching amendment coded 13839 to House Bill 1922, please signify by saying aye. Those opposed? You adopt. Sir, we're on your bill as amended.
Thank you, Mr. Chairman. Thank you, committee. This bill was brought by their Attorney General in Washington County, and it prohibits sexual offenders, violent sexual offenders, or violent juvenile sexual offenders to knowingly rent or offer to rent a swimming pool, hot tub, or other bodies of water for use for swimming that is located on property owned or leased by the offender or otherwise under the control of the offender.
Members, you've heard the explanation of the bill. First up, I have Chairman Doggett. You're recognized.
Thank you, Mr. Chairman. To the sponsor, is this some issue that you're seeing in your area at home?
Representative Hicks.
Thank you, Mr. Chairman. Yes, it is. In our district, this has been going on where sexual offenders are actually renting out, leasing out their swimming pool or hot tub for things like birthday parties and such. So it was brought to our attention, and we thought it was time to do something about that. Yeah.
Chairman Doggett.
Are the offenders staying on the premises while these parties are going on, or is this, or are they there present? Or are they using just leasing out or renting out their facility? How's that work? I'm sorry.
Representative Hicks.
Thank you, Mr. Chairman. Well, we wouldn't know whether they was staying there or not, but I would imagine that would be the whole object of what they're trying to do, is probably staying there. And you know, we don't really feel like we want grandma, mom, grandpa. We don't want anybody there during that time. So that's the reason, you know, it's not specifically for children, but yes, they're probably staying there.
Chairman Doggett.
When they advertise that they have pools and hot tubs for rent, are they also advertising that they are indeed sexual offenders?
Representative Hicks.
Thank you, Mr. Chairman. No, I don't believe they are advertising that.
Chairman Doggett.
Very good bill. Thank you very much.
Thank you.
Any other discussion? Representative Griffey, you're recognized.
Thank you very much, Mr. Chairman. Thank you for bringing this bill. Is it safe to say, or do you know, have there been any criminal offenses conducted as a result of this yet? Is a sex offender done something to some child or some other person as part of this renting out? Do you know if there's been any observation? You know, if you know.
Representative Hicks.
Thank you, Mr. Chairman. I don't know personally, but this was brought by our district attorney general from Washington County, so I would assume that
It's probably safe to say that your attorney general probably feels like his hands are tied. He can't do anything unless there's a law that prevents this from going on. So he's got no way to really investigate that and determine whether somebody's doing something illegal or inappropriate regarding this activity.
Representative Hicks.
Thank you, Mr. Chairman. Yes, that is a fact, because in this instance, there is a contract probably signed by the parent. That's the reason in part of the bill that it takes the parent, the liability away from the parent. So when that happens, yes, we have to create a law to try to fix this issue.
Representative Griffin.
Thank you, Mr. Chairman. Well, it sounds like if we pass this bill, maybe we'll prevent some child from potentially from being abused or worse by passing this bill. So thank you for bringing it. Thank you, Mr. Chairman.
Yes, sir. Thank you. Next on my list, I have Chairman Halsey. You recognized.
Thank you, Mr. Chairman. I'm just trying to get clear in my head here. Would it be offense against this bill if it passes if the offender's not there, he's not home, and he rents this swimming pool in his backyard to a birthday party going to go on for 3 families going to get together and swim, and he's not even there? That makes him guilty even though he's not present, right?
Representative Hicks.
Thank you, Mr. Chairman. Yes.
I don't know if we ought to dig around that.
And I actually have a question along those lines, and I just wasn't clear on it. So if there's someone who's on the registry who owns a hotel, for example, and that hotel is a swimming pool, is that, I mean, it's not where they live, it's an investment that they have or a business that they have. I'm sure that's unusual, but I'm just trying to figure out, would that be an offense under this bill? You're recognized.
Mr. Chairman, I would think that it would be an offense. I really would think that it would be an offense. I mean, we would hope that a sexual offender would not own a hotel as well. I mean, thank you, Mr. Chairman.
Yes, sir, you're recognized.
This really opens up a lot of areas here. We've talked about horse riding stables. We've talked about all different kinds of ways that these folks can figure out ways to get to children and families. So this is something that I know I've heard that in the future they're going to be rewriting a lot of this law, and that is all needs to be taken into consideration when this is done.
Okay, very good. Representative Beck, you're recognized.
Thank you, Mr. Chairman. To the sponsor, Chairman Moody was very concerned about how this might affect her Cabana Boys. Is there any overlap?
Representative Hicks, if you dare.
Thank you, Mr. Chairman. We would not want to touch that for certain. That's for certain.
Chairman Moody.
For the record, I do not own a swimming pool. Thank you.
All right. All right. Without objection, we're ready to vote. All those in favor of sending House Bill 1922 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you head to calendar and rules.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. That brings us to item number 8, House Bill 1459 by Representative Hakeem. Sir, you have a motion and a second. I also see that you have an amendment, and that is coded, make sure I get it right, 13376. Is that the one you wish to move forward with?
Yes, sir.
You have a motion and a second on the amendment. You are recognized. The amendment does make the bill, so we'll go ahead and get that on the bill. All those in favor of adopting amendment coded 13376 to House Bill 1459, please signify by saying aye. Aye. Those opposed? You adopt. You recognize, sir.
Thank you, Mr. Chairman and members. This bill has, when I say it's gone through somewhat of a process, we needed the understanding from legal. They've been very helpful in this process. From our leadership of General Assembly, been fortunate to have input. And so what we have is a bill that deals with domestic violence. And one of the things we want to bring out is that in the year 2020, we had nearly 70,000 cases of domestic violence. And there's 14 categories in that range. And one of the second most egregious offense was aggravated assault. And in aggravated assault, this is where we have cause serious bodily injury to the alleged domestic abuse victim, strangled or attempted to strangle the alleged domestic abuse victim, used or displayed a deadly weapon. Now, what this bill will do presently in law, the court can hold an individual for 12 hours if they deem it's appropriate, if they deem there's no threat to the individual. What this bill does is raises that timeline from 12 hours to 24 hours. Reason for that is that to bring out hopefully cooler heads from the perpetrator and afforded an opportunity for the person who may have been the victim to make that decision if they need to seek emergency shelter or some other avenue. And to do that for that 24 hours, again, it's at the discretion of the magistrate or the judge for that to take place. And that is the central facts. I just would note one other item, is that in the United States, Tennessee is ranked number 5 in the nation when it comes to deaths after domestic violence events. And of course, we would want to be in a position where this doesn't happen in the state of Tennessee. And so we're asking support of this bill moving forward. Thank you, Mr. Chairman.
Members, you've heard the explanation. Chairman Holsey, you're recognized.
Thank you, Mr. Chairman. I just want to make sure of one thing. You're exactly correct. Right now, under existing law, you have to stay incarcerated for 12 hours on a domestic violence you've been arrested for before you can get out. And you think another 12 hours is a benefit, but this is going to be decided by the magistrate, right? Doesn't force him to do it. If he thinks the circumstances are there that he needs it, he can do it. And is that the way the bill reads?
That is correct, sir.
Okay, thank you.
Any further? Chairman Dixie, you're recognized.
Representative Hakeem, I think I've seen situations where 12 hours just may not be enough for someone to relocate or find solace in another place. I think 24 hours does help someone, especially when you, I've seen people that may have their support system may live out of town.
Yes, sir.
Or it gives them enough time to make the adequate arrangements before, moving forward. So I think that this could be a good piece of legislation if enacted.
Thank you, sir. I'm sorry.
Yes, sir. Did you wish to respond?
Just say thank you.
Okay, excellent. Next on my list, I have Chairman Russell.
Thank you, Chairman, and thank you, sponsor, for bringing this legislation. It's something I'm glad to support. I do have a clarifying question. It says 24 hours after the person's released. If a person's arrested for this offense, I believe they had to stay 12 hours, and then is it an additional 24 hours?
No, sir.
Okay.
No, I apologize.
So you recognized.
Okay, thank you. In total, it would be 24 hours. And that second 12-hour time period within that would be at the discretion of the magistrate or the judge if they deem there may be danger to the victim.
Chairman Russell.
Great bill. Thank you.
All right, thank you, sir.
Any further discussion? Any objection to the question? Seeing none. All those in favor of sending House Bill 1459 as amended to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman and members.
Thank you. Finally, that brings us to item number 9, House Bill 1323 by Representative Hardaway. Representative Hardaway, you're recognized. Sir, you have a motion and a second.
Thank you, Chairman. And House Bill 1323 is very simple and straightforward. It requires an officer that's responding to a domestic violence situation to provide certain information to the victims in reference to the availability of GPS monitoring as a condition of bail.
Members, you've heard the explanation. Any questions? Any objection to the question? Seeing none, all those in favor of sending House Bill 1323 to calendar and rules, please signify by saying aye. Aye. Those opposed? Sir, you had to calendar and rules.
Thank you, Chairman. Thank you, members.
Thank you, sir. Members, that concludes our calendar for today, and we stand adjourned.